Looks like it's 7 o'clock, so I'll get us started here for tonight. If anybody joins in a few minutes, that's all right. We'll catch them up to speed. Hi everyone, thanks for coming. My name is Meg. I'm the marketing and outreach librarian here at the Lyon Township Public Library, and I want to thank you all for joining us tonight for our presentation, Suddenly Single Estate Planning and Financial Planning for Those on Their Own. And I want to thank you, of course, to Jonathan for coming here tonight to give this presentation. Before he gets started, I have a few housekeeping details just for the Zoom meeting before to inform you guys about. So if you're having any technology pains, if something's freezing, you can't hear, you can't see, please let me know in the chat. I'll try to see if I can fix it. There's only so much I can do, but maybe we can figure it out. If you get kicked out of the Zoom meeting for any reason, or the Zoom meeting ends, I'm hoping that the weather stays like it is and we don't get some freak storm and the power goes out. But if you do get kicked out, you can log in using the same link that you used to get into the meeting initially. We are recording this event, so keep that in mind. If you need to leave a little bit early, I will be able to send out the recording to you to watch later. And in terms of questions, if you have any questions throughout the presentation, you can put them in the chat. You can unmute yourself if you're comfortable with that and ask your question out loud. Otherwise, put it in the chat. I will see it and I will ask the question for you. Next, I wanted to invite you all, if you enjoyed this presentation or this event or Lyon Township events in general, we've got a few other great events coming up in the next couple weeks. Next week, we have Thoroughbreds and Whiskey, the fascinating history of Kentucky bourbon and the Kentucky Derby. So if that interests you, that's next week on Wednesday, the 20th at 6 p.m. That will also be virtual. At the end of the month, we have another virtual program, Anishinaabe 101. This is part of our 12th annual Community Reads event, which we do with the Neighborhood Library Association. We're reading the book, The Firekeeper's Daughter. So if you're interested in the Native American history and Indigenous people of the state of Michigan and Lower Canada, that would be a great one to attend as well. That's on the 27th at 6 p.m. Lastly, if you have any feedback about our programs, you enjoy a program or a particular presenter or topic, you can let us know in our program survey. That allows us to kind of plan events in the future that meet our community's needs and wants. So that's super helpful. If you want to fill that out, I'm putting that in the chat now. And without further ado, I'm going to pass it off to Jonathan to start on our presentation for tonight.
Thank you very much. Thank you for coming tonight. I appreciate you taking your time and listening to today's presentation. And again, if you have questions, feel free to jump in either through the chat or to unmute yourself. I'm here to educate you, inform you of various information. So to give you a little background, I am an attorney and CPA, and so I work with Bloom Associates. We're in Farmington Hills, Michigan. And then our other firm is Bloom Advisors, which is an asset management company. So one thing I would just say with me wearing my CPA hat is, as you're aware, April 18th, you get a couple extra days this year, is the income tax deadline. So hopefully your returns have been filed. Just a little background on that as well. Hopefully you're filing it electronically, either through your CPA or doing it yourself, because the IRS is definitely backed up from last year's income tax returns. And there are some people who still have not received refunds from last year. So if you're able to file a return either through a CPA or yourself, I would definitely recommend doing that electronically. Just a brief, last year, I actually filed my return by paper just because I owed an amount. Of course, it was filed with the check, and I get a letter a couple months ago that said, we did not receive your income tax return, but they did cash the check. So electronically definitely is what I've done this year, but it's something I do recommend. So hopefully everyone is moving forward with that within the next few days. Okay, so what we're going to discuss is the situation when either, as we say, there's subtly single situation. Someone passes away, a spouse passes away, or you have become divorced, and what occurs during those situations and things that you need to consider and what you need to do. both from a legal standpoint and also from a financial standpoint. And a lot of times they do go hand in hand, but you need to consider those situations in both circumstances, either a death of a partner or a divorce. And then, as I said, I'm happy to answer questions throughout, as well as if there are any at the end that anything comes up. So feel free to ask your questions if need be. So the first situation is if there is a death. So assuming a couple is married, one of the individuals passes away. So one of the first circumstances one has to take a look at is with regard to income taxes. Again, as I said, that's the time of the year. And how does one file their income tax return? So usually in the year of death of one individual, the survivor can still file that income tax return, as we say, married, filing jointly. And that typically results in the best income tax situation generally. There's a lot of cases or some cases where that may not be the case, but generally it is best to file that married filing jointly. And again, what happens is in a situation like that, they look at what the situation is as of December 31. So if a person passed away on December 31, you're still eligible to file that married filing jointly. Another situation you can file is married filing separately. This may result in some additional tax being owed, but there are some cases that may be beneficial. One of the cases may be is if the individual who passed or the other spouse, if they were still living, but we're talking in a death situation, would be if that person had debts or liabilities against them from either other creditors or from the IRS or from the state of Michigan. So if you file jointly, and let's say there was a refund and that individual owed money to the IRS or the state of Michigan, the taxing agency can take that refund. So in those type of cases, we would say, well, file it separately. And assuming that person who does not have the debt or anything like that is then picking up the refund on their personal return, they would get that. But there are some cases why it makes sense to file separately, and it's really just a case-by-case basis. So that needs to be determined during lifetime as well as upon a death situation. And the best result is it should be reviewed either on your own or with your accountant on what results in the best tax advantage or less amount of tax being paid. Another situation is the qualifying widower. So what happens is after there's a death of an individual and a couple is married, that survivor for a 2-year time frame, assuming there's a dependent child, can file married filing jointly. And again, that results in a lesser income tax being owed. The other situation, which could occur obviously if there's a younger minor child or after a divorce and an individual is taking care of that child and picking up that person on their tax purposes for their exemption or credits, is the head of household. So generally the qualifying widower is for 2 years after death, assuming there is a dependent child. If they're after that 2-year time frame, you can use a head of household. So the head of household is better than filing just as a single individual, but it still will result, all things being equal, more tax than if you were married filing jointly. So it just depends under the circumstances how you should file your income tax returns. And again, if you have a CPA who assists you with your return, you inform them of a death, that CPA will go over that information with you and to find out what's the best method and status to file. If you're doing that on your own, and if you're doing your own program, be it tax cuts, TurboTax, anything like that, then they walk you through the questions through the interview. And again, that program would generally tell you what the best situation would be in your circumstances. So income taxes are definitely something one needs to take into consideration. Another to do is when I have a client come to me after there is a death, the status is, what do we do at this point? What do we do? So the first thing I really say is taking a sheet of paper and really making 3 columns. And the first column is to determine what assets there are. So nothing gets left behind, nothing falls through the cracks, and you're gathering all the assets. So how one can determine that is looking at the prior tax returns. If there are monthly or quarterly statements that are sent, looking at those statements to see what assets there are. The other thing I always tell clients is to do a search on the internet through the Michigan Department of Treasury. And what you can search is Michigan unclaimed property. And in some cases, you may have some money that you were not aware of, or the deceased person was not aware of, that you may be able to make a claim. So it's Michigan unclaimed property. They ask for name, certain other information, I think possibly social security number or the last 4 digits. And you can then determine if the state is holding something for you or for the deceased person. And if it's for the deceased person, we'll discuss there may be the need for a probate, but I always say, take a look at the Michigan unclaimed property. So when doing this list, as I said, you want to make certain nothing gets left behind and you're gathering all of the assets. So the second list or column really is how were those assets owned? So the first column is what asset is there? The second column is how was that asset owned? And the third column is for the date of death value. And we'll discuss all these in a few moments, but those are really the starting point when someone passes to start the process to gather the assets and make certain that you're receiving all of the assets. When one is receiving a pension, so when the deceased person is receiving a pension and they pass away, the surviving spouse would need to contact that pension company and inform them of the death. In some cases, that pension amount may change. It may be a lesser amount. In some unique cases, there may not be any pension. It just depends on what determination that surviving pension recipient selected during their lifetime. When the second person passes away, typically that pension then stops. But you definitely want to contact that company so you can inform them of the death, and that pension still will continue to be received. Similar to that is the Social Security, which is paid by the United States government. And typically, a funeral home will notify the Social Security Administration of the death. And frequently, that last Social Security payment will be returned to the government. But it depends on the dates and various things like that. But as I said, typically the funeral home will notify the Social Security Administration. At some point too, usually I'm going to say it's maybe a week to 2 weeks. It could be a little longer. You will receive a death certificate and you will need to obtain several. Just depends on the amount of assets you have as far as different accounts and things like that. So requesting a certain number of death certificates will be necessary as well, because in a lot of cases, the financial institutions, pension company, life insurance companies are going to want to see potentially either receive the original death certificate, or they may just want a copy of it. So you'll want to receive some copies, originals of the death certificate. So with Social Security at that point, if one is of age to be receiving Social Security, then you need to contact Social Security, and then they can assist to make a determination what's the best method. Are you to receive your own Social Security amount, or potentially you can then receive your spouse's Social Security amount, where if that is a higher amount, you will be entitled to that greater amount. So you'll need to generally set up a meeting with Social Security after the passing of someone to determine if that amount will be greater than what you're receiving on your own. We also, in a divorce context, will discuss that as well. But upon a death, you definitely want to contact Social Security to maximize that amount you're entitled to. Again, with any type of death situation or change situation, you want to review your beneficiaries. So if you have a 401k plan through work or a 403b plan through a hospital or a public university or something like that, as well as your individual retirement accounts, you want to confirm who the beneficiaries are. And I tell clients, actually, it makes sense to confirm that periodically, even before a death situation, because a lot of times I've had clients say, well, I thought I named my spouse as the beneficiary, and they actually receive the information from the financial institution and there's nobody named. And that presents an issue as far as maybe probate or things like that. So you want to make certain that you've appointed a beneficiary. And again, if a spouse has died, you want to review who that beneficiary is. If that person you had maybe named 20 years ago and maybe never updated it is still who you want. In most cases, it's usually going to the children, but maybe in some cases not. The other thing to look at in that consideration is to, again, if you've only named the spouse and that spouse dies before you and you do not have a beneficiary named and then you pass away, that asset needs to be probated. So one of the big things I always say in estate planning is let's avoid a probate. And a probate, if you've been through it, is not a quick process. It's somewhat of an expensive process. It's a public forum, and the goal would be to avoid a probate. So again, when there is a death, you should take a look at your retirement accounts, your life insurance beneficiaries, your IRA beneficiaries, to make certain that those are correct and updated. So that's something that should be done. Again, not just upon a death situation, but currently. But for certain, when there is a death, that should be done as well. Another thing we need to take a look into is when one passes, there is something called an estate tax. It's really a death tax, and it's a federal tax. Michigan does not have an estate tax. Some other states do. So if you have property, real property in another state, it's possible there could be a tax when there's a death. But as far as the federal estate tax, what the IRS does is they add everything up at the time of death to say, what are the value of all your assets? And if that amount exceeds the threshold, then there may be an estate tax return due within 9 months of the date of death. And this year, that exemption amount is $12,040,000. And in that case, if your assets are above that, then you have a return due. If your assets are below that 12 million threshold, and again, excuse me, $12,060,000, if that amount is below that threshold, then you're not worried about an estate tax. And you can, one less tax return that you have to worry about. Another consideration when there's a death is, as I said, in that second column, based on each individual asset, how was that asset owned? So as I discussed, probate is a legal process to have an asset transferred. And what that means is if the deceased person had an asset in their name alone and they pass away, there is no beneficiary, it's not part of a trust, it's not jointly owned with anybody else, it will need to be probated. So for example, if a husband had a bank account in his name alone and he passed away, and the spouse then goes to the bank and says, well, my husband passed, I want to get access to this account, I want the money, the bank is going to deny that because they don't know who that person is. She doesn't have the authority. So what happens is you go through the probate process to obtain that authority. And as I said, it's something you want to avoid. So in certain cases, you can do, in order to avoid a probate, you can have a revocable trust in the asset owned by the trust. You can have an asset owned as joint tenants with rights of survivorship. So again, if it's husband and wife, the husband passes away, by law, it goes to that survivor. You can have what's called a pay on death account. Or certain things, like I said, an IRA or life insurance has a beneficiary. So those are ways to avoid probate. The probate process, as I said, can be lengthy depending on the assets. It's not a quick process, and it's a public forum. The other probate process is if an asset is owned by an individual. So again, let's say the husband had a bank account of $5,000 in his name. If there's a threshold, which is less than $25,000, then it becomes a simple probate, what we call a small estate. And it's really a 2-page form that gets filed with the probate court. Certain information is given to the probate court in order to obtain that. And then in that situation, you receive an order from the court, and then that order can then be given, let's say, to the bank, and the bank needs to follow what that says. Usually it will then go to the spouse or the spouse and the children, just depends on the amounts and things like that. So those are the probate process. Again, the goal I recommend is to avoid a probate situation. Now, when there's a death, either through probate or through, if there is a revocable trust owned by the individual, there then may need be an income tax return for the trust or for the estate. And that is what we call a Form 1041. Your personal return is called a Form 1040. Typically, and I'm a CPA, I avoid doing the Form 1041s. I usually have a CPA do those and prepare those returns. They're a bit more complex. They're done less so than individual returns. So from that standpoint, you really would want to have a professional. But if there is a trust, then what happens is when there's a death, there would then need to be generally, it depends on the trust document, but in some cases, there would need to be, for a husband and wife, in some cases, there may need to be a tax ID number obtained for the trust at that point. If it's a surviving individual or single person, they pass away and they have a trust, definitely at that point, a tax ID number needs to be obtained. And generally, it's not difficult to do that. But again, a professional is usually recommended to obtain that tax ID number. So when there is a death, what happens is if assets are owned in the trust, they typically then need to be retitled. So the successor trustee would then be in charge of those assets under the new tax ID number. So that's the process. And at that point, that successor trustee would then follow what the trust document says. So assuming one person passed away, the assets would then be distributed according to their trust documents. And as I said, until all the assets are fully distributed, so it could be a 2-year time frame. Let's say it's the latter part of the year, then the following year until all the assets are distributed, you'd have 2 trust income tax returns. So once all of the assets are distributed out, there would be a final trust income tax return, and that would no longer be necessary after that point because there's no longer any assets in the trust. As I said previously, with regard to estate planning, when there is a death of an individual, if it's just a single individual, at that point, that deceased person cannot revise or change any of their estate planning documents. But if one is married, that surviving spouse definitely needs to review their documents to see what it says as far as who the successors were. And again, depends how long the document was last reviewed or written. I've had documents that are over 30, 35, 40 years, and clients say, no, I don't want that person. Again, our children were young. I want our children to act, various things like that. So it really makes sense to review who the successors are in the documents, and just to go over what proper estate planning documents I recommend. One is generally a revocable trust. So assets are moved into the trust. During your lifetime, you use those assets however you choose to. For income tax purposes, it's reported on your personal return, so it's still using your Social Security number. And you use those assets how you want. The trust document would say upon death or upon incapacity, who's in charge of your assets. And so that's important. Most people think, well, I only have to worry about a death situation. It's also if one becomes incapacitated, they no longer have their faculties to maybe handle their own affairs. So the trust would then spell out how you want your assets to be distributed. Again, generally it's going to children. It could be going to other family members, to charities, but you spell out what your wishes are. And there's no legal requirement that the assets be split equally between the children, or in some cases, one child may get their money immediately. Another child may have it spread out over time for whatever difficulties or issues that child may be having. So that distribution scheme needs to be determined and potentially revised in your trust. And the same is also true if you have any personal items. I always tell clients, if you have any jewelry, artwork, collectibles, memorabilia, tools, anything, sporting equipment that you want somebody to receive, then you should spell that out so that there's not fights. I actually have a client who has a collectible car from, I think it's 1955, and he spelled out in his document which child is receiving that asset, because you can't split a car or a wedding ring. So it definitely avoids fights. The will, you appoint a personal representative. Generally, that personal representative would file the last income tax returns. A lot of times it's the same person as who the successor trustee is. But the other function of the personal representative is if there is a probate, then that person oversees and handles the probate proceeding. There's medical care documents, and that's a big thing that if you don't have medical care documents, you can go on our website, Bloom Advisors, and you can download what's called a declaration for medical care. Sometimes it's known as a living will or a medical power of attorney. Basically, you are appointing a patient advocate to make your healthcare decisions if you are not able to make those yourself. So as long as you're able to make your decisions, you do so. If you're not able to, you're in surgery where they have you out, you're in a coma, you're in life support where you cannot communicate, then that patient advocate would make healthcare decisions for you. They're stepping in your shoes. So that could be allowing certain treatment. It could be not allowing certain treatment, or again, if one was on life support, potentially terminating life support. So those decisions and issues need to be discussed with whoever you appoint as the patient advocate, and obviously need to be discussed before one has a situation. The general durable power of attorney, that is for financial decisions. And again, just as the medical document, it's only valid during lifetime. So upon a passing, that general durable power of attorney for financial documents stops. So you are allowing that, what we call the agent. And again, if one is married, typically it's a spouse. If the spouse is not alive, then in some cases it's generally a child or children, to act on your behalf with whatever you can do financially. So if it's, let's say you were not able to any longer file a tax return, you have an asset in your name and you have a trust, transferring that asset into the trust. Again, that person is stepping in your shoes, filing or defending a lawsuit. It's quite broad. So really whatever you can do financially, that agent can do on your behalf. And then the other update would be with regard to the deed for your house. So assuming husband and wife owned property when they bought the house as what we call either joint tenants with rights of survivorship or tenants by the entireties, means the same thing, that when one dies, the survivor is the legal owner of the property. But then the issue you have, just not with real estate, but with joint accounts, be it bank accounts, be it investment accounts, brokerage accounts. If one spouse dies, the survivor is the sole owner. And if that second person then dies, it needs to be probated. So those accounts, again, if you have a trust, need to be moved into the trust. If you have a deed, and we'll discuss it in a moment, there needs to be a type of deed transferring it into the trust. So again, the intent when you have a trust is most assets are owned by the trust. Retirement accounts have beneficiaries, again, which generally would be the spouse, then the children, but in some cases, the trust could be the beneficiary. So you really want to review your estate planning documents if you have them. If you do not have estate planning documents, it really makes sense to put those in place. And as I said, it's just not upon a death situation, it's also an incapacity situation. A couple other documents we prepare when we do estate planning. One is for digital assets. Obviously, we are on Zoom and we're now in a digital world. And what happens with that is if you have any type of accounts online, so it could be you have a bank account that's online and it's not a brick and mortar similar to a local bank, but it's just online where you transfer them money, then that's deemed to be a digital asset. So any type of digital asset, any type of automatic bill paying, any type of social media, tablets, computers, really anything with a username or password, email, this document for digital assets controls that and says, okay, I'm having my spouse or my child has the right to deal with anything that's deemed to be a digital asset. So that is a newer document. And then another document that's a bit newer, and it just depends on the circumstances, is when one dies, what do they want with their remains? So in those cases where I have clients who either have or want organ donation, or they want to be cremated, or in some cases, I haven't had frequently, but in some cases, they want to specify how they want their funeral service, then this needs to be spelled out in a document. We call it a funeral representative designation. And again, it's spelled out. So I had a situation, this was before the law changed a few years ago, where the client wanted to be cremated. And the law at that time was the next of kin, who in my client's case was the mother, who they had not spoken in 30 years. So the client wanted to be cremated. It was stated in the will. And for about a month after the individual died, the mother did not allow the body to be cremated. Well, with this new document, if one wants to be cremated, it happens pretty quickly. So this document is prepared, it's given to the funeral home, whoever's been appointed, the representative, again, either the spouse or the children, would then specify to the funeral home, this is what needs to be done. And it's legally binding because that is your wish when you drafted and signed this document during your lifetime. So those are really the documents that need to be reviewed. If you don't have them, they should be implemented. I mentioned about a deed. So what we've been using for years now is a type of deed to avoid a probate situation. So in a lot of cases, what I'll say in the old days, a deed was prepared by, let's say, a husband and wife or an individual that just says, I'm transferring it to my trust, I'm transferring it to my children, and upon my death, they'll find the deed and it will get recorded. Well, the problem with that is if the deed is lost, and now that individual passes away or the individuals pass away, and the deed cannot be found, now there needs to be a probate. So that's one reason we don't do that any longer. Another downside is some parents will say, well, I'm just going to add my child to my deed. I'm going to record it, which is fine. It avoids a probate. And they record it as what we call joint tenants with rights of survivorship. And as I said previously, when there's a death, the survivor or the last person standing becomes the legal owner on that property. So let's say if it was mom and daughter, mom passes away, it was joint tenants with rights of survivorship, daughter is now the owner on that property. Well, there's a downside to that. And the downside is if that other owner who really didn't do anything for the property just to avoid a probate situation gets sued, that plaintiff, that creditor can go after that asset. And so a lot of cases, clients will say, well, I'll just add my child to my brokerage account, which has some significant assets in it or value in it. And I say, that's not something I recommend, because if that person, that child gets sued, they can fully go after your account, which is not your intent. The other thing is with a divorce situation. So if that child were to become divorced, that could be used in a divorce, what we'll call equitable settlement. With a bank account or brokerage accounts, the downside to that as well is, and I've seen it unfortunately, is where a child takes the money from parent to their detriment. So with regard to accounts and things like that, in most cases, we don't recommend joint tenants with rights to survivorship. We would generally recommend putting it into the trust or maybe having a pay on death account to avoid a probate. With real estate, the likelihood is if it's owned by two people, a child generally is not going to be able to sell their interest because a purchaser is going to want to own the property in full. They're not going to want to have another partner on the property. But the type of deed we now use in order to avoid a probate is what we call a ladybird deed. And what this means is you own the real estate for your lifetime. You can do anything you want on it. You can sell it, you can refinance it, you can farm on it, you can lease on it. Anything you can legally do, you can do because it's your property during your lifetime. And what this deed says is upon death, it goes to a recipient, to a beneficiary. Now, when we have trust involved, we generally state that the trust is the beneficiary. If one does not have a trust, then it may just go directly to the children. And so under the circumstances, it just depends what's the best method. But the way to look at it is it's saying that upon death, the real estate is being transferred to a beneficiary. And so this deed gets recorded now in the county where you live. Then with the city or the township, there's some paperwork that gets filed with the city or the township. And again, the goal of doing this ladybird deed and recording it now is it avoids a probate because it says, if I own this property at the time of death, it goes into my trust. So again, probate is avoided. It does not change anything with your property taxes. So it remains the same because you're still the owner on the property. And another benefit of this is if one has to go into a nursing home and they spend down their assets and they qualify for Medicaid, then the home is an exempt asset. So there is some benefit from a nursing home or Medicaid perspective as far as some planning what you can do with the house. Okay. So that's really dealing with a death situation. The other situation is when there's a divorce. In some cases, maybe a divorce was forthcoming over a period of time. Maybe it was quickly, but whoever files for divorce in Michigan, there is no requirement of why there is a filing for a divorce. So it's what we call a no-fault state. But a divorce proceeding occurs, and what does one do at that point? So again, similar if you have estate planning documents and you are now divorced, you need to update those documents. You typically don't want that former spouse to be the successor trustee over your assets. Generally, the divorce decree will state that the former spouse is not entitled to assets under your trust, but I don't leave anything to chance. I would revise the revocable trust to say, for example, upon my death, these assets are going to my children or to other beneficiaries, not to my former spouse. So that definitely needs to be updated. The same is true if you have a minor child or children. So age of majority is 18. So if you have children that are less than 18 and you pass away, then the other parents of those minor children have legal custody of the children. Okay. But let's say that other spouse passed away first and you should have a will. And I always tell clients when there are minor children, this is the most important aspect. You need to appoint a guardian, which means if you pass away, who do the children live with? Who makes daily living decisions, health decisions? They step in your shoes as the parent until that minor child becomes age 18. So this would be included in a will. So if the other spouse passes away, you would want to specify in your will who that guardian would be. It may be a close friend, it may be one of your siblings, things of that. So you really need to make that decision. But again, with all these medical documents, the power of attorney, you want to, upon a divorce, no longer, I'm going to say generally no longer, have that former spouse as that person making decisions for you. So you then would need to update those documents. And again, if you don't have estate planning documents in place after a divorce, generally it really makes sense to do so. The same is true with the deed to determine what beneficiary is on that deed, and again, to avoid a probate situation. Again, with a divorce, you want to review who the beneficiaries are on any type of 401k plans, 403b plans, retirement plans through work, on your IRA accounts, regular IRA accounts, Roth IRA accounts, who those beneficiaries are, so they are listed properly and no longer the spouse. The same is also true for any type of life insurance, or if you also have any type of annuities. So I would throw annuities in this context as well. With your retirement plan through your employer, there are cases out there that have said you've appointed, let's say, your former spouse as the beneficiary on your 401k plan. You now pass away and you don't update your beneficiary on that 401k plan. There are cases that state that surviving former spouse now gets all of your retirement money from your employer. I'm going to say in most cases, probably greater than 99%, you probably don't want that former spouse to receive that money. So you need to update through your employer the beneficiary on those retirement employer plans so that they match your wishes currently and no longer have that former spouse listed. Again, with your divorce, they take a look, the IRS, of what your filing status was as of December 31. So I have seen some clients who a divorce is being finalized, it's probably finalized, and they will wait to January, first part of January, to actually file the divorce, because again, a couple married filing jointly results generally in a better tax situation than two individuals filing single. So again, typically the divorce attorneys will discuss that. You may have your CPAs involved, but the last income tax return as a married couple is determined what is your status as December 31st. So in that situation where pretty much they had everything situated, they file the paperwork for divorce, let's say the first or second week of January, that prior year they would file married filing jointly. Then the new year, assuming that person did not get remarried, would then just file again, as stated above, either as a single individual or a head of household. Because there's not a death, you cannot file the 2 years after the qualifying widower, because this is a divorce situation. Following the divorce, certain things need to be looked at from a transaction standpoint. During the divorce, it's usually determined who would retain the house. In some cases, maybe the home is just sold and proceeds are then given to both parties. But if a individual is going to be remaining in the home after the divorce, the other person who no longer will be the owner will need to sign a deed transferring their ownership to the person who would now be the sole owner of that property. And that deed gets recorded into with the Register of Deeds. In most cases, the divorce attorneys will do that. In some cases, the divorce attorneys will need the assistance of an estate planning attorney. But the bottom line is, if you are remaining in the home, you will need to receive a deed showing that you have full ownership, and the divorce decree will specify that. Again, the divorce decree will also specify how retirement benefits are being split, and that also goes into the financial aspect, which we'll discuss shortly. But the divorce decree will state what happens with retirement benefits, what happens with other assets. If it's bank accounts, if it's non-retirement accounts, brokerage accounts, how those assets are being split. and what's being done under the divorce decree. And again, the divorce attorneys will discuss that with your input to try and have that equitable settlement. The other thing to consider when there is a divorce, again, when one is of Social Security age, what's the best benefit that you can receive? So when one is married, they are entitled for that time frame of the marriage, that former spouse's their share of spousal benefit. So it may make sense. Let's say in some cases, a person was taking care of the children, they didn't work. Definitely in that case, then they would want to take the spousal benefit once they're eligible for Social Security, because that amount will be greater because they didn't have any Social Security credits. So again, when one is eligible, if there's a divorce, you'll need to show to Social Security the divorce decree, and they can help determine what would be the best situation to receive for Social Security when you're eligible to either take your own benefits or the portion for your spouse during that time frame. So that's something to consider as well. What happens now when there's either a death situation or a divorce? You are now on your own, and that can be a scary situation for a lot of people, and it's quite understandable. And what happens is you now have one income as opposed to two. Your expenses may be the same, possibly. They may have to go down. So the first thing to do, just as we tell clients when they invest, once you are now on your own, what are your goals? What are your objectives? Potentially, you may move out of the house. You may, let's say, be in an apartment, renting something for a short time is a goal to buy a new home or a condominium. So that needs to be determined. And what is your objective as far as with your assets? So all that needs to be determined. In doing so, generally the first thing I would say is you need to take a look at your cash flow. If one is looking at their income sources, they would be looking at their wages that they receive, or if they running their own business, how much income they're earning during the year. If one is receiving child support, again, for the minor child or children, that stops at age 18. If one is receiving alimony for a certain period of time. So you really need to take a look at what are your income sources, and that total figure, whatever it may be, you need to compare that to what your expenses are. And just as in most households, you need to have a positive number where your income is greater than your expenses. Unfortunately, our government doesn't, but they're able to borrow. You and I are not able to borrow for our living needs. So the income definitely does need to exceed the expenses. And in some cases, those expenses very well may change. Again, you may potentially need to downsize a house where maybe your children who are now adults are no longer living in the home. There's a lot of property taxes, insurance, utilities, where it no longer makes sense, where if you're just on your own. And so hypothetically, maybe a condominium could be a better situation. You don't have to worry about snow service, various things of that sort, grass cutting, other services. Obviously, you need to take into consideration the monthly maintenance fees, but all that comes into play. And that, as I said, could be a scary situation. And in a lot of cases, that person, yourself, may never really have dealt much with the family finances. So you may very well be in a unique circumstance where now you're doing things on your own, you're paying bills. Maybe you don't even know how to pay bills online, and that's not uncommon. And so you need to learn some of these items to be comfortable. But after a period of time, I have found clients figure it out with assistance and so on, and that they are not stressed as they were from the beginning point after the death or the divorce. The other thing when you're looking at financial planning after a death or divorce is with those assets that you have, with the assets that you receive potentially through the divorce, what is your risk tolerance? And you want to have a growing portfolio because, as we know, specifically this year, there is inflation, and you need to cover growth in the portfolio so that it grows for the future and that those assets are in a growing mode. Now, that doesn't mean you take unnecessary risk. If your risk is, let's say, a conservative or very conservative level, you're not going to have your investments in an aggressive standpoint. You're going to have more bonds than you would stocks. But you need to make that determination of how much risk you're willing to assume. And obviously, when the stock market's going up, like it had been, everyone's very happy. They don't really take a look into maybe how much risk they should be taking or how that portfolio is structured. When there's a downturn, such as we've had this past several months, people take a closer look at that. But generally, over the long-term horizon, and that's how we look at investing as a long-term horizon, is to have a growth mode in the portfolio, but you still can have growth even if you're conservative or ultra-conservative. So you need to determine how much risk you're willing to accept and how that portfolio should be balanced. And again, going and determining what your goals are with this money, what your objectives are. It could be, as I said, setting aside money to purchase a new house. It could be maybe funding grandchildren's or children's college funds. It could be a trip or a home improvement, or typically retirement planning. So those objectives and goals need to be determined. In a lot of cases, we have clients either upon a death or a divorce, they were not the financial person in charge. And a lot of times they need assistance to determine, how do we determine all of this? How do I invest my assets? How do I invest my retirement accounts or my 401k account? And so in that case, a professional can assist you. And as I said, that is something we do frequently, but you really would need the assistance if you've never done it before, because you don't want to just stick your money in a bank account. Now, yes, in a short term, that could be beneficial, but as you're aware, we had about 8% inflation, they said, over the last year. Your bank account, savings account, they are not paying you 8%. I will guarantee you that. It's probably less than 1%. So the bank is making money on your money. So you need to determine how to invest this money so it grows for you, and a professional can assist you. The other thing thereafter, again, if you are not dealing with finances, you will have to file income tax returns each year. And so you will need to speak to, possibly, if you were married, the accountant who did your taxes previously. You may be able to prepare returns on your own using a tax program, or you may need a referral for a new accountant or CPA to prepare your tax returns. So from that standpoint, you need to take taxes into consideration. And again, looking at the excess flow of cash, taking expenses and income into consideration, you also need to consider taxes. And if one's no longer working, they're now receiving IRA distributions, you can have withholding from the IRA distribution. You still may need to make an estimated quarterly tax payment. And again, that's where the CPA can assist you as well. The other thing, as I mentioned, is you're on your own. You're not living with two people or more potentially. The children are out of the house. You may need to downsize your house. Part of that process would be from a cash flow standpoint. Can you afford still staying in your house? Can you afford or want to have a smaller house? The other consideration is, when you are downsizing, getting rid of many things. That's a perfect time to get rid of items that you no longer need, and either doing it on your own. I know there are companies that help people who are downsizing to, ask them questions, come into the home, get rid of things they don't need. Obviously, certain things are necessities. Some of those necessities, I would say, would be various documents. For example, your estate planning documents. You either want to keep in a safe deposit box or in a safe to let the children know or successors know that you have those documents, that they've been appointed. In most cases, I generally recommend a parent telling a child that, yes, I have estate planning documents. Here's where they're kept. You may or may not choose to discuss that with them. You may revise your documents periodically. But generally, the medical documents I would give to the children so that they have it, so that if there were a medical emergency for yourself, they can deal with your medical decision making. But there's other documents, like I said, the deed for the house, assuming a ladybird deed was done, it's transferred either to the beneficiary or the trust. That should be kept with your documents. Birth certificates, passports, anything of importance really should be known where those are. The other thing I recommend, which I fully recommend, what assets do you have? Really having a listing of those assets, account numbers, what institution they're at. If you do things online, so either online accounts that you review or have, or actually even also bill paying, utilities, company credit cards, things like that. I recommend having a list of what's the website to get on it, what's the username, what's the password, so that people are not scrambling. If it's in your head and you become incapacitated or you pass away, that does not do the successors or your family or children any good to state and have access to those various assets. It makes sense to have a listing of doctors, professionals, CPAs, attorneys. If you are on medications, having a listing of medications, the dosage, the amounts, how often, how frequently, so that your children, they can assist you, or whomever can assist you if you have doctor appointments and need some assistance. So that really makes sense to have all that information organized. And I have had clients who get very stressed out when the parents' documents, there's no organization to it. They're scrambling. And compared to clients who are very well organized, the children are able to find the information. The client may have different folders or files, and they're very well organized, and it makes that process after one passes away or incapacity to deal with one's assets and financial situation very easily.
If you wouldn't mind answering it real quick, it says from Annette, if one is not comfortable naming a family member or friend as successor trustee, or the person who will have medical power of attorney or durable power of attorney, what do you recommend?
Okay, so there's a couple of things. So let me start with the medical document first. Generally, a financial institution, they don't know you. Generally, they are not going to make healthcare decisions for you. Banks and financial institutions are very, what I'll say, conservative. They don't want any potential lawsuits against them. So as far as healthcare decisions, typically that is going to have to be a friend, family member. It could be a clergy member, potentially, if you're close with. There are some organizations that do that. I am not familiar with that, but I do know there are some, and they go through an interview process with you. But generally, for the the healthcare decisions, generally it's recommended that it be a family member or a friend. Okay. Now with the financial documents, the trust, the will, the general durable power of attorney, you can name, if I sort of call it, if there's a compelling reason that you're not naming a friend or family member or anything like that, then there are banks that are trust companies. So a bank could act in that capacity on your behalf. When they act, their fees are obviously greater than if a friend or family member is doing it based on their schedule of fees. Usually it's based on a percentage of assets. But if it makes sense that you just don't have anyone you feel comfortable, and that's the key, that successor is someone, first of all, you trust. And then secondly, they're going to follow what your document says, and you know they're going to do what is right, then you're appointing that person. But if you don't have that confidence in whomever, then a bank will do that. The benefit is, yes, they're going to do it, and they're going to do it very well. The downside is, let's say if assets are to be distributed over time to children or grandchildren, there's less of a personal relationship that bank has, as opposed to if you name, let's say, your sibling who knows your children or grandchildren. So there are positives for having a bank. There are negatives for having a bank. But the biggest issue would be if you have no one to choose from, or you don't feel comfortable choosing anyone, then the bank definitely should be a successor or trustee on the trust, in the will, and the power of attorney. Okay. I'm not sure, were there any other questions currently?
So far, that's it.
Okay, all right. So as far as I said, that on our website, bloomadvisors.com, there is a medical document. You can download that and complete that. There is what we call a statutory will, which basically is pretty basic. That says I either give it to my spouse, or if my spouse is not alive, or I don't have a spouse, then it's going to my children. It's very basic. It's not, you can't adjust this if you wanted to give certain other friends or family members distributions, then you'd have to have a professional prepare a will for you. But if you have nothing, at least that is a start. A lot of younger people will use a statutory will potentially, but if you have more complex assets or financial situation or children, then generally a will or a trust would come into play. That's for certain. We also have various podcasts, if it's on investing, if it's on other estate planning issues, other tax issues. So I recommend, if that's something you're interested in, there are items on our website that you can listen to from prior discussions or items that we have moving forward. I think that's all I have at this point. If there are any questions, I'm happy to take them. If you have questions in the future, you want to email me. On the bottom of this page has my email address. I'd be happy to answer those questions for you.
I will reiterate what Jonathan just said. If you have any questions right now, this is the perfect time. You can put them in the chat, or you can unmute yourself if you're comfortable and ask that way. If not, Jonathan has graciously left his email, so you can always send him an email later. Also, I have recorded this presentation, so as long as we don't have any technical difficulties, we will get that posted onto our YouTube, and I'll send it to all of you and everyone who was unable to attend but registered, so you can watch or refer to his slides at a later date and at your own pace.
Like I said, if anyone wants to send me an email, I'm happy to respond to that. That is all I have. I appreciate you having me tonight. And if I can be of assistance in the future, I would love to help out.
Thank you so much. Well, it was super informative. I know that it was good we got a thank you from Annette.
Okay.
It was great to lay out the steps that anyone would need to go through in either of those situations. So, but it looks like we're good with questions. So we will end this here tonight. And thank you so much again for coming in and giving us that presentation.
You're welcome. Thank you for having me.
Mm-hmm.
Have a good night.
Good night.
Take care.
Thanks for coming.
Bye.